Good morning. This is the Colorado Energy and Carbon Management Commission. This is our second day of weekly business meetings. It is August 24th. We will start with a roll call.
Yes, Mr. Chair. Commissioner Ackerman,
Here.
Commissioner Cross,
Present.
Commissioner McGowan,
Here.
Commissioner Messner,
Here.
Commissioner Oath, Commissioner Ray,
Here.
Commissioner Robbins.
Here.
Mr. Chair, you have 6 out of 7 commissioners present today.
Great. Good morning, everybody. Good to see folks. We have one matter on our agenda today. It is docket 230700230. It involves the applicant Diamond G Concrete, and it involves an orphan well application, which is something that we've not heard before. So with that, I would like our staff to elevate Attorney Dave Neslin, as well as whomever from staff may be interested in participating with us. And I really don't know who that is, if it's Dave Andrews, Orphan Well Program Manager, or Greg Duranolo in charge of environment and et cetera. Give me just a second, Mr. Neslin. Let me get the appropriate staff member up as well, if possible. I'm looking at the list. I don't see either of the folks I identified. So, Mr. Neslin, if we could you identify yourself for the record and your client?
Yes, Commissioner, I'm Dave Neslin with the law firm of Davis, Graham & Stubbs, appearing on behalf of the applicant, Diamond G Concrete Company. I have a number of colleagues who will be testifying with me, and they do not seem to be on the panel. I don't know if there's a problem.
I saw in your pre-hearing statement that you had Barb Brunk and David Rao as witnesses. Is that right?
That is correct. And my colleagues, Laura Reese and Natalie Bolt. They should all be on this panel.
All right. I see Miss Reese is a attendee. We'll get her elevated. Who is the other attorney? Natalie, somebody?
Natalie Bolt, B-O-L-D-T.
Okay, she's in the panel. We'll get her elevated.
And then Ms. Brunk and Mr. Rao will both be testifying.
All right, we got Ms. Brunk is in the panel. We'll get her on board. I'm not seeing Mr.
Rao, R-A-U. There he is. I think we're all here now.
Okay.
Robbins, are we ready to begin?
Yeah, can you give me a sketch of your anticipated time here this morning, Mr. Neslin?
Commissioner, we've been allotted 30 minutes for our presentation. I think we'll be able to complete it in 20 minutes or maybe a little more than that.
Okay. You are welcome to begin.
Thank you very much. Commissioners, again, I'm Dave Neslin with the law firm of Davis, Graham & Stubbs, appearing on behalf of the applicant, Diamond G Concrete Company. With me this morning are my colleagues, Laura Reese and Natalie Bolt, as well as 2 expert witnesses who will testify this morning, Barbara Brunk of Resource Conservation Partners and David Rao of Paragon Consulting. Also in attendance but not testifying are Reggie Golden and Drew Golden of Diamond G Concrete Company. To begin with, we thank you and the hearing staff for promptly scheduling this morning's hearing and allocating us 30 minutes to present our case, which is uncontested. Next slide, please. Diamond G Concrete Company owns a parcel of property in Longmont, which is currently used to grow alfalfa and is planned for future development. On the property is the Tanaka 111 well, which was plugged in 1995 and is now orphaned. Diamond G Concrete Company only became aware of the well this April when oil from the well bubbled to the surface. This July, after filing a complaint and consulting with the ECMC staff, Diamond G Concrete Company submitted an application to transfer the Tanaka well to the Orphan Well Program for expedited plugging, abandonment, and remediation work. That application is the subject of this morning's hearing, and it was the subject of supporting written comments by 4 local governments: Boulder County, the City of Longmont, the Town of Erie, and Adams County. We understand this is a matter of first impression, As set forth in our pre-hearing statement, we believe the case is straightforward. The application should be granted based on the undisputed facts, which are taken from the Commission's own files and publications by other government agencies, largely, and descriptions of the Orphan Well program, which are taken from this Commission's FAQ document describing the program and Director Murphy's request last year to the federal government for program funding. Next slide. Let's begin by briefly summarizing the relevant history of the Tanaka Well. In 1985, the well was drilled by Noarco Resources. In 1990, the well was conveyed to Meyer Oil Company, a sole proprietorship owned by Douglas Paul Meyer. In 1995, the well was plugged and abandoned by Meyer. In 1996, Meyer's debts were discharged by a U.S. bankruptcy court. And in 2011, the ECMC released the bond for the well. Next slide. Here's Exhibit I, Attachment 7 to our application, which is the Form 10 documenting the change of operator for the well to the Meyer Oil Company in 1990. Next slide. Here is Exhibit I, Attachment 13 to the application, which is the Form 4 documenting Meyer's plugging of the well in 1995. Next slide. This is Exhibit G, which is the bankruptcy court order discharging the debts of Douglas Paul Meyer, the sole proprietor of the Meyer Oil Company in 1997. Next slide. And here's Exhibit H, which is the ECMC's notice releasing the plugging bond for the Tanaka Well in 2011. As you can see, it states that as of that date, the Meyer Oil Company no longer operated in Colorado, and its debts had been discharged by the bankruptcy court. I'll now introduce Barb Brunk, who'll tell you about the area in question. Barb?
Basic things. Again, good morning, Chairman Robbins and Commissioners. I am Barb Brunk. I'm a landscape architect licensed to practice in Colorado. My practice centers on land use permitting and review for municipal governments and private landowners. And I've been working with the Golden family on this piece of property for over 20 years. I will add information to illustrate where Tanaka 111 is relative to existing conditions and future plans for the property under and in close proximity to the well. You can see in this aerial photograph, I actually was out there yesterday standing on the site, and I could smell oil, and there is still evidence of discharge on the surface of the property. In the background on this, all the way to the left, is a public school, and those are existing homes adjacent to the property. This well is near numerous residences, commercial buildings, and heavily public used roads. Within 1,600 feet of that public school that shows up in this photograph, within a disproportionately impacted community, and within a mile of other DICs, near numerous ditches and subsurface conduits, within a mile of 19 groundwater wells, and within a mile of high priority habitats for aquatic native species, bald eagles, and black bears. Next slide. The property under the well is zoned residential mixed use. It's been preliminary platted, and existing streets and utilities are in place to serve this property and the adjacent property. Next slide. Per the City of Longmont Ward redistricting math, there is a population of approximately 4,300 within 1 mile of this well. You can see on this aerial photograph, again, the Tanaka Well and the public school, riparian habitat and public trail corridors along St. Vrain Creek, Left Hand Creek, and these are high priority wildlife, water resource, and trail corridors within the City of Longmont. The City of Longmont Recreation Center and Museum, commercial development, a gravel mine next door that's actually in active dewatering, existing homes, including single family and multifamily, existing affordable and attainable housing at the Blue Vista PUD, existing land lease manufactured homes at the Countryside Village, and existing agricultural workers housing, the Casa de la Esperanza, operated by the Boulder County Housing Authority. Next slide. This site is located within a disproportionately impacted community where the population exceeds the percentage of the minority population in Boulder County, located within 1 mile of census tracts where the percent of minority population exceeds 50%, and located within a mile of census tracts where the median household income is below poverty. Next slide. There are many surface and subsurface conduits for water on and near this property. Creek corridors, irrigation ditches, old agricultural drain tiles, and a dewatering operation on that adjacent gravel mine. Dave Rao will talk a little bit more about the specifics of these in his presentation, but I just wanted to give you the context. Next slide. This shows the location of those 19 groundwater wells within 1 mile. And what is note is there's some rural residential homes along Quail Road to the south, and those residents actually use their groundwater wells to water their yards and their gardens. Next slide. The well is located within 1 mile of several high priority habitats. You can see the blue area, which is the black bear habitat, the Rule 1220 aquatic species conservation waters. And again, this is St. Vrain Creek and Left Hand Creek. And this is the most restrictive habitat protection zone under the ECMC rules. City of Longmont regulations also limit disturbance adjacent to and within the riparian corridors and require water quality control measures for any runoff entering the creeks. The other piece you can see there is the bald eagle habitat. I'll now hand the presentation over to Dave Rao, who's going to talk about environmental considerations relative to the leaking well. Thank you.
Thank you, Barb. So in this slide, you can see the photo on the left is what I observed when I first arrived on the site on April 11th. You can see the crude oil that had been discharged to the surface. And if you look in the center of that orange area, you can see that there's oil that's being discharged under pressure, and there's some bubbling going on. And so there was clearly pressure. The next photograph shows that same area after I removed a little soil with a shovel. And then the last photograph on the right is the soil sample I collected that day, which was actually the 18th when we came back, and ECMC staff were present. They also collected a soil sample, and we'll talk about that a little bit later. But if you look closely at that sample, you can see that there's free oil within the soil matrix. Next slide, please. So this is a picture that showed, or an annotated USGS map that shows the area, and the green line is the bonus ditch. There are a number of subsurface drains. The information regarding those drains is a little spotty. The depth of groundwater is 5 to 6 feet. These drains are pretty typical, and I know this from my practice. I practice in the area of environmental engineering and soil and groundwater remediation, as well as water rights, and I'm very familiar with agricultural practices. So what historically happened is when these ditches, like the bonus ditch, were installed and laterals associated with them, there's always seepage from those ditches and laterals, creating a rise in the groundwater table. In order to facilitate agricultural production, the landowners would install subsurface drains to convey that groundwater back to the river, and thus drawing the water table down and allowing them to use the land for agricultural production. So it's always a balance between delivering irrigation water and keeping the groundwater table reasonable. These drains typically conveyed water to the nearby downslope surface water bodies, so they operated by gravity. In this case, that would be St. Vrain Creek. And I believe this groundwater discharges to St. Vrain Creek. There's also some dewatering that occurs up above the bubble that's got the 4 on it. And so that's also drawing groundwater that way. The natural groundwater flow direction is northeast. In my experience, once crude oil or contaminated groundwater reaches these drains, it's almost immediately conveyed to the point of discharge, which in this case would be St. Vrain Creek. In my professional opinion, that creates a real and present risk of contamination to these surface water bodies. Next slide. This is a slide that shows the registered wells that we identified from the Division of Water Resources website. As can be seen from this image, there are a number of wells that are down and cross gradient from the Tanaka well, that is northeast and east. Some of these wells are permitted for domestic use. Barb mentioned watering gardens and landscaping with them, but people also can drink from these wells. And again, since this contamination has leaked up from the wellhead, it's interacting with the groundwater table and creating a real and present risk to these groundwater resources. Next slide, please. So this is an interesting slide. This is an excerpt of the data summary table for the sample we collected. And there's a typo. The sample date was actually the 18th. But this is a sample that we analyzed. Again, ECMC staff collected a sample as well, but we have not seen any results from that sample. If you look at the first row, those are the results of the analysis of that sample that was in the jar that I showed. The next row is the samples that we collected for waste profiling, because once we removed some soil from the area around the wellhead, we had to dispose of it properly. So we had it profiled and disposed of. The next row is the next 3 rows you guys are very familiar with. It's a 915-1 cleanup standards. It's interesting to note that, for example, the TPH value is, and I think everyone's familiar with total petroleum hydrocarbons, but the TPH value is 80 to 100 times the ECMC standard, and the benzene value is highlighted here, and that value is 18,500 times the groundwater protection standard. The toluene value is approximately 520 times the groundwater protection standard. Ethylbenzene is at 78 times the groundwater protection standard. The trimethylbenzene result is 43,300 times the standard. Excuse me. And the 1,3,5 trimethylbenzene result is approximately 11,400 times the standard. And the 1-methyl naphthalene value is approximately 25,000 times the standard. These numbers, to me, are conclusive in documenting the fact that the release and discharge of crude oil around this well have resulted in conditions that will impact groundwater quality and continue to impact groundwater quality, and have likely already impacted groundwater quality until the wells or the contaminations remediated. And Barb pointed out that she could smell the discharge of oil approximately 500 or 600 feet from the spill site, which indicates to me that there are air emissions occurring at the site. With that, I'll hand it back to Dave Neslin.
Thanks very much, David. I now want to share some excerpts from the Commission's FAQ document describing the Orphan Well Program and Director Murphy's letter to the federal government last year seeking program funding. These documents confirm that the Tanaka well should be transferred to the Orphan Well Program and prioritized for expedited plugging, abandonment, and remediation work. To begin with, the Tanaka well is an orphaned well. The ECMC rules define an orphaned well as a well for which no owner or operator can be found. Here, the last owner and operator of the well, Meyer Oil Company, ceased operating in Colorado and was discharged from bankruptcy more than 25 years ago. Their phone number is no longer in service. According to the commission's records, the last letter the commission sent them was returned as undeliverable, and the Secretary of State has no record whatsoever of their existence. The commission's FAQ document describing the orphan well program and the letter to the federal government seeking program funding also explain that the program is appropriate for wells whose operators have been discharged from bankruptcy. In other words, those wells are orphan wells. Here again, the last operator of the well was discharged from bankruptcy, confirming that the well is in fact an orphaned well. Next slide. Next, the Tanaka well should be transferred to the orphan well program. The commission's FAQ document says just that. If there is not an oil and gas operator responsible for an identified well, as here, then the site is then registered into the orphan well program. The FAQ document also states that members of the public may refer wells to the orphan well program through a complaint. And here, Diamond G Concrete Company, the landowner, filed a complaint in April, which is Exhibit M, and also consulted with the ECMC staff. So the applicant followed the orphan well referral process outlined by the commission and exhausted its remedies with the staff. Next slide. Finally, the Tanaka well should be prioritized for expedited plugging and remediation work. This commission has set forth several risk factors for this purpose in both the FAQ document and the letter to the federal government, and these risks are present here. A leak was confirmed by the staff in April, as reflected by the inspection report and photos, exhibits K and L. According to Ms. Brunk, the well is still leaking. The well had a history of compliance issues and was last inspected more than 25 years ago. Vegetation impacts were likewise confirmed by the staff in April, as documented by the same exhibits. Urbanization is confirmed, significant urbanization is confirmed by the aerial photograph and plat, Exhibit C, and Ms. Brunk's testimony, which indicates that more than 4,000 people live within a mile of the well. Potential environmental impacts and significant environmental risks are confirmed by Mr. Rao's testimony and Exhibits B, K, and L. And the location is within a disproportionately impacted community as confirmed by the commission map and Exhibits S, T, and U, which indicate that the well is within one disproportionately impacted community and within a mile of two other disproportionately impacted communities. Other factors that warrant expedited work include the nearby public school, numerous water delivery ditches and subsurface conduits on the property, 19 nearby water wells, and the nearby aquatic native species, conservation waters, and other high priority habitats, which are set forth on exhibits C, D, V, W, and X. All of these factors heighten the risks associated with this well. Prioritization is therefore appropriate to fulfill the legislature's mandate that you protect and minimize adverse impacts to public health, safety, welfare, the environment, and wildlife resources, as set forth in Section 3460-106, Subpart 2.5, as well as the efforts to the same end of this administration. Next slide. Before concluding, I just want to emphasize that this presents a unique situation. The application is uncontested. The last operator ceased operating and was discharged from bankruptcy more than 25 years ago. The well and surrounding area involve exceptional circumstances and heightened risks, as described by Ms. Bruck and Mr. Rao. And this is reportedly the first such application in the 30-year history of the program. Next slide. Under these circumstances, we ask that you grant the application, that you add the Tanaka well to the orphan well program, and that you prioritize the well for expedited plugging abandonment, and remediation. Thank you for your attention. We welcome your questions.
Thank you very much for the presentation. At this time, two things. We will allow the commissioners to ask questions of the panel. And then following that, I want to give our staff an opportunity to make any presentation that they desire to make with regard to the issue of placement on the orphan well and with regard to the issue of whether the commission should involve itself in the prioritization issue. I would note for the record that we did receive public comment in favor of placement of the well on the orphan well list from Boulder County and Adams County and the cities of Longmont and Erie. With that, if we could stop the screen share, I'll be able to see everybody a little bit better. That would be helpful. And then does any commissioner have questions of this panel? Commissioner McGowan.
Thank you, Mr. Chair, and thank you for the presentation today. I just have a couple of questions. So the first question I think is, I feel like someone said that the Golden family owned the property, but this is on behalf of the Diamond Concrete Corporation. So who owns the property and for how long?
It might be best, Ms. Brunk, if you answered that.
Diamond G owns the property, and it was transferred to Diamond G Concrete about 18 months ago, maybe 2 years. Before that, it belonged to the Golden family under one of their entities. And as the property, when Costco came along, they transferred it into a different entity to develop the site. But it's been in the Golden family and the Golden entities for a long time. And that when I said I worked with them for 20 years on the property, it's because Golden Farm LLLP owned the ground, and that is the Golden family.
Okay.
Sorry for the confusion.
No, thank you. That's helpful. And then I'm wondering if you could, when the property was transferred, there must have been some sort of review of the property and what was on the property and some sort of inspection of the property. So someone must have been aware that the well was there, correct or no? No one knew the well was on the
We
property.
did not know the well was there. Again, I've been walking across that alfalfa field for a long time. And somebody called us and said, there's something on the surface of this ground. And that's when we discovered that there was a well on the property.
Thank you. So what was this person doing when they saw the seepage in the ground? How was
They
this
were actually, it was an environmental, a portion of the property was under contract for development, and they were having their own phase 1 done on back to the review. And they were on the site doing their phase 1, and they noticed it and called us.
Okay. So I noticed in one of your pictures, there's what appeared to be some pretty hefty tire tracks on top of the well. And I'm just wondering if any kind of heavy machinery was involved in the discovery of this well or what was happening there.
The discovery of the well was because of the spot on the ground. I let Dave talk to the tracks of the machinery, Dave Rao.
Thanks, Barb. So Commissioner McGowan, when we discovered the spill, we brought a small backhoe on the property to remove some soil in an effort to try and identify what was going on. At that time, we were unaware of the existence of the well, and we thought it might be a flow line. So that's what those tire tracks are from that tractor.
Okay. So then I assume also that this property has been zoned for residential and being prepared for development.
Ms. Brunk, you're muted.
I got it. Yeah. Yes, the property is zoned for mixed residential, and the roads are there and the utilities are there to develop around the well. Not necessarily, nobody can do anything under that well until we figure out what's going on to it. But adjacent property is zoned and preliminary platted and ready to be developed.
Okay.
And actually, the piece to the north of Bountiful is slated for development as a public-private partnership between the city of Longmont and to develop affordable and attainable housing. So more people will be coming into the neighborhood in the area immediately around the well.
Okay, thank you. And then I'll have questions for staff.
Any other questions for the panel? All right, seeing none, if we could elevate Deputy Director Cuthbertson, or he's elevated, if you could visualize. Good morning. Did you have anything from staff's perspective on sort of, I think we have two issues before us. One, whether to place the well on the orphan well list. And then two, whether the commission ought to weigh in on the issue of prioritization.
Thank you, Chair. So the director has no position regarding the placement of this well in the orphan well program. We do have concerns about expectations of it being expedited. The orphan well program has an established risk assessment profile that it goes through to rank different locations. We have a number of locations not dissimilar from this that are on the list of sites to be remediated, to be replugged and abandoned and remediated. Presumably this well needs to be replugged. That's a presumption. We do, I won't go into that rabbit hole, but presumably it needs to be replugged, and obviously there needs to be some soil remediation from the pictures we've seen, if not further groundwater remediation. Those projects can be time consuming. Groundwater remediation can take at least months, sometimes more than a year's worth of months. And so all of that work is scheduled based on the risk profile that all of the sites in the orphan well program present. And this situation has occurred previously. Mr. Neslin referred to this being the first application of such in his memory or his knowledge. That might be the first in my knowledge as well, but I've only been for the commission a short time. This came about after we reviewed our surface development policy last year. And in the review of that, we didn't find the authority within the director's statutory authority or rule delegated authority to essentially take the property, take responsibility for someone's property, even though it may be an unwanted piece of property. And in consultation with the Attorney General's office, we revised our surface development policy, and our hearings team developed a very simple pro se type application that surface owners could use to make an affirmative request to the commission to not be responsible for the well, for the commission to become responsible for the well. So we did that to try to facilitate an affirmative request by the property owner for the commission to become the responsible party for the well. We felt like that was an appropriate level of process. We couldn't find any other process authorized by the statute or the rules, and so that policy was redeveloped. And this just happens to be the first occasion when this issue has been addressed since the redevelopment of that policy. So that's sort of the background, and I guess all the input that I believe is relevant, maybe.
Thank you, Deputy Director Cuthbertson. Appreciate that perspective. Helps me with sort of the second issue relative to prioritization. Does any commissioner have further questions of Deputy Director Cuthbertson? Commissioner McGowan's got her hand raised.
Thank you. And I'm going to try not to go down the rabbit hole with you, Deputy Director. So when you say that we have a prioritization process, if something is burbling and bubbling like this, I'm assuming that we would do something in the interim to prevent that. But what you're saying is longer term, doing the full remediation and everything that needs to be done might take longer based on what's happening in the other wells in our portfolio. We wouldn't just let that sit there and leak, would we?
I can't imagine the scenario where we would probably not create an emergency plugging contract at least. But contracting takes months typically, and we already have months worth of work scheduled. So the remediation, there might be some attenuation for any imminent impacts. But especially if there's been a groundwater impact and we become the responsible party for the well, we will not release the property until we have cleaned up the groundwater. And so, you know, the other thought I had that I forgot to mention, and I apologize, is, you know, in response to Mr. Neslin's observation, these kinds of situations have occurred in the past. And if, you know, different surface owners have chosen to either hire an operator or become an operator even in order to contract for the remediation of the property in a time that is within their liking, that's a possibility, and it has happened in other cases. You know, the primary concern we have is we do have a number of high priority sites like this that we are addressing as expediently as possible. And so we would just really appreciate, I hope that the commission could appreciate that an external expediting of the issue will be it could potentially be disruptive to other sites that are similarly being impacted that have already been scheduled for operations.
Thank you. And you may not know the answer to this, and maybe this is something we can discuss at a future commission meeting, but in this circumstance, would this well be eligible for either our federal, the federal funding that we're getting for orphan wells and plugging them, and or our orphan well program and how it's set up?
I believe either.
Okay.
Either of those fund sources could be used to address this well once if it is in the orphan well program.
I think that's all for now. Thank you very much.
Other questions for Deputy Director Cuthbertson? Commissioner Ackerman?
Thank you, Mr. Chair. My question's a little bit remedial, so please forgive me, Deputy Director Cuthbertson. This is my first orphan well application that's come since I've been on the commission for the past year. Is there generally an administrative process to add orphan wells and in a way that doesn't come to the commission, or do each of these come to the commission? Is the application the trigger? Can you elucidate me on that a little bit?
Thanks, Commissioner Ackerman. As Mr. Neslin indicated, wells have routinely been added to the orphan well program administratively in the past. But as we reviewed, and it was just a routine review of policy that prompted the questions that we asked with the Attorney General's office. This policy was one of the policies that we were going through to review, and especially in light of anticipating significant federal grant funds and with the development of the orphan well mitigation enterprise fee that we're charging operators, and the creation of that orphan well mitigation enterprise board. We just felt like we wanted to make sure we had reviewed all the associated policies. In the review of that policy, we could not find the express statutory authority or rule-driven authority that allowed the director to essentially take the property, to accept the property. And like I said, in working out what we felt like was the minimal process possible, we felt like that at the very least, the commission needed some affirmative request from the surface owner for the commission to become the responsible party. And the only forum that we could find for that was the commission and not the director.
Thank you, Deputy Director. I really appreciate that. And I think you touched on my other primary issue, which was the issue of prioritization by the commission or through staff process. Thank you for your thoughts on that.
Commissioner McGowan?
Sorry, but so are we saying that from here forward, if someone wants to request a well be put into the orphan well program, they need to go in front of the commission? Is that what we just said?
That's what our redeveloped policy says. Yes, ma'am. And
Okay.
like I mentioned, Hearings has developed a very simple one-page template oriented toward a pro se applicant to simply make that affirmative request as the surface property owner. You know, in our contemplation of these requests, we can't contemplate the director. We can only contemplate one scenario where the director might resist such an application, and that would be the scenario where the property owner has damaged the well, and we would suggest that in that case, the property owner be held responsible for repairing the well if they had damaged the well.
So I'm
there
going
may
to, Deputy Cuthbert, let me just halt this line of inquiry. I think what we need to do is we need to focus on the application at hand as opposed to policies and processes. We can certainly have discussions around policies and processes afterward, but so not that these are not valid areas of inquiry. Let's just focus in on what's before us first, and then maybe get into areas of inquiry around changes or other things. Noting again for all of us that this is a case of first impression. We've not had to deal with this before. AG Davenport, I see you had visualized yourself. Did you have anything to add?
No, Chair, you covered it.
Okay. All right. So any final questions for the panel or Deputy Director Cuthbertson relative to the well at hand? Yes, Mr. Neslin, did you have any final thoughts?
Yeah, if we could have just a brief opportunity to respond to Deputy Director Cuthbertson, because we'd not heard or seen the presentation
Go ahead.
this morning. Thank you. As a backdrop to this, let me just clarify. The legislature was very, very clear, crystal clear, that a property owner like Diamond G Concrete Company here is not responsible for cleaning up after an oil and gas operation. And this is part of the statute. And I'll just read you an excerpt from it because it is crystal clear. It says, responsible party does not include any landowner, whether of the surface estate, mineral estate, or both, who does not engage in or assume responsibility for the conduct of oil and gas operations. So this is not Superfund. It's not CERCLA. There's no liability for pollution because we own the property. In fact, it's just the opposite. The legislature has directed just the opposite. Landowners are not required to clean up after oil and gas operations. That is why there is an orphan well program. That is why the industry provides funding for that program, and you have sought federal funding for that program. Second, references to the agency becoming responsible for the property. I just want to clarify. All that we're asking for is that the agency becomes responsible for repairing the plugging job on the well, doing some additional plugging work on the well so that it is not continuing to leak oil, and remediating any contamination that has occurred associated with the leaking well. That the agency is not going to be acquiring any ownership or interest in the property or any other control over the property. You're simply becoming you are becoming the responsible party for purposes of the additional plugging and remediation work that is necessary at the well. I understand Commissioner, or excuse me, Deputy Director Cuthbertson explained that there was some question about how wells could be added to the program. Again, I just want to clarify your own publications, the FAQ document, your letter to the federal government seeking funding a year ago state that wells can be added to the program through a complaint process by a member of the public filing a complaint, which is what the applicant did here. They followed your process. And last, again, since the initial leakage was discovered in April, and the commission staff visited the well at that point in time. 4 months have passed. I appreciate your question, Commissioner McGowan, about if there's bubbling oil, shouldn't somebody be doing something about that on behalf of the agency? Unfortunately, no action to our knowledge has occurred to date. Nothing is being done about that. So we do believe it's appropriate on this record, given the exceptional circumstances that Ms. Brunk and Mr. Rao have identified, for the commission to direct that this well should be prioritized for expedited plugging and abandonment and remediation work as needed. And certainly, we would expect to speak with the staff about what that means in practice. We're not looking to displace other work or disrupt other ongoing work. At the same time, an agency with the experience and the scope of this agency and the resources available to it, we believe is capable of adding this well to your ongoing program on an expedited basis, on a prioritized basis, so that the ongoing leakage can be cleaned up and some additional plugging or whatever is necessary can be done to keep the well from continuing to leak. Ms. Reese, Mr. Rao, Ms. Brunk, any of you wish to add to what I had to say?
I would just say that time is of the essence, because when it's leaking, it gets bigger over time. And so the urgency is about not letting it get bigger over time. And I think that's everybody's urgency about the environment and the neighborhood and the resources, that if we can get to it sooner, we may not have a big remediation, groundwater remediation thing. That containment is, I guess, not the expert, but from the common sense point of view, containment.
So as an expert, I'm a professional engineer who's practiced in the area of soil and groundwater remediation for 35 years. The cost is just going to go up exponentially if we don't stop the continued leakage. I always use the analogy of horses getting out of the barn. The horses are running out of the barn into the pasture, and we need to shut the barn door so no more horses get out, and then we can round up the horses that are in the pasture. It will go up in cost exponentially from my experience, and I've cleaned up thousands of sites.
Great. Thank you to the panel. One final look around for questions to the panel from commissioners. All right, seeing no questions, I'll start with deliberations. This matter, this well ought to be placed on the orphan well list. I think that is pretty self-evident. I, as one commissioner, am aware of the testimony that the well ought to be elevated. However, I believe that our orphan well program and its functionality in terms of determining prioritization of wells across the state does a good job of figuring out the correct priority. And so while I would instruct Deputy Director Cuthbertson to be aware of the information as presented to us today about the urgency, the expedient nature of trying to handle this well once it's on the orphan well list, I would leave it to Dave Andrews and his orphan well program to determine where this well fits within the priority of all the orphan wells that are out there. I've got some other thoughts about process that I will reserve until after we've deliberated on this particular well. Does any other commissioner desire to further deliberate? Or do we have a motion? Commissioner Messner?
Thank you, Mr. Chair. I will make a motion, and I concur with your thoughts on that. I do think that the state's orphan well program is the appropriate place for this well. I also believe that the state's orphan well program has significant experience associated with orphan wells around the state and determining the necessary prioritization to ensure protection of public health, safety, welfare, the environment, and wildlife resources. It's clear from the testimony that was provided today that there is some need for expediency associated with this, but as Deputy Director Cuthbertson indicated, that's the case with a number of wells, and I don't think it's good practice for this commission to artificially insert an expedited process into a structure that has been developed by professionals within the orphan well program to determine where certain wells lie on the priority list. And so with that, I would move to approve the adoption of this well into the orphan well program and allow the prioritization of this well within the orphan well program to be done by the staff associated with the orphan well program as appropriate and as per their policy.
Commissioner Ackerman.
Thank you, Mr. Chair. I concur with the statements made by you and Commissioner Messner and second the motion.
Further deliberation? Commissioner McGowan.
Thank you, Mr. Chair. I agree with my fellow commissioners, but I will add just my own narrative, which is I don't think from the plugging perspective, I understand that remediation and figuring out long-term how things need to be handled. I would hope that this would just naturally rise to the top of our prioritization list as part of the orphan well program. When something is visibly leaking like that, I think if you're a citizen and you're a commissioner, this is concerning to see. So that's just my 2 cents, take it for what it is, but I agree with the motion.
Further discussion? Seeing no further discussion, all those in favor of the motion signify by saying aye. Aye.
Aye.
Any opposed? Motion carries. Thank you, Mr. Neslin, and your panel for the presentation. Thank you to Deputy Director Cuthbertson for the presentation. The matter is concluded. The motion is approved. The well is placed on the orphan well list, and staff will determine priority issues relative to the well and next steps. With that, that matter is concluded. And so we can unelevate the folks that were relative to the well, and then we can have further discussion amongst ourselves. And I will initiate that further discussion. I think a couple of things. One, I appreciate our staff, coming up with some form of a solution relative to placing matters on the orphan well list. I, as one commissioner, would like our staff and us as commission to make the process more streamlined. One, I think if we, are aware of a leaky well, as Commissioner McGowan has pointed out a couple of times, we ought to be able to act expediently and get out there and do something to keep the horses in the barn, as one witness testified. And, I know I preface these points by noting that our orphan well program is phenomenal. It is best in the nation, if not best in the world, and they do a fantastic job. But if we need to reevaluate the concept of how newly found potential orphan wells get on the list, let's just do that. If this was discovered some months ago and Mr. Neslin does a great job, and this is not a bash on lawyers, but the concept of needing to lawyer up to get an orphan well potential onto the orphan well list doesn't make a lot of sense to this commissioner. And I think maybe other commissioners may have already spoken to that point. So I think there is some opportunity to refine the process, an opportunity to administratively streamline that process. And I also want our staff to feel comfortable to use the commission in whatever category is appropriate to make sure that we are appropriately reviewing potential orphan wells and getting them on the list. So if that needs to be something that comes to us, that's great. And I heard Deputy Director Cuthbertson say a couple of times pro se process. Pro se means not a lawyer process. And so maybe we need to help figure out how the pro se really means pro se, so that folks can feel comfortable if they find something and they've not contributed to that something, that they could get it over here to us so that we can use the abundance of funds that we have not taxpayer funds, thank you very much, but industry funds in our orphan well program to take care of these sorts of issues. So those are my process thoughts that I wanted to get out there once we were done with the actual application. And I'm sure others may have other thoughts as well. And maybe we need to, set up a time to have a discussion with Deputy Director Cuthbertson and Dave Andrews, our orphan well program manager, to make sure that we've created a good process for Coloradans to bring these matters to our attention and get them taken care of. Anybody else with thoughts? Commissioner Ackerman, then Commissioner McGowan.
Yeah, I'm a broken record today, Mr. Chair, but no additional thoughts that could be articulated better than that. I wholeheartedly agree and would advocate for setting some time for a discussion with staff.
Thank you, Commissioner McGowan.
Agree with everything.
And seeing other nodding of heads. Okay, with that, I think the commission direction to staff is so given. And I believe that concludes the, hey, Deputy Director Cuthbertson.
I'm just curious if the commissioners might want us to send them a copy of the policy and the hearing template, just so you don't have to search for it. If that would be convenient, I'd be happy to email that to the commissioners.
That would be great. And
so you can see what we tried to do and how it can be improved.
Yeah, no, I think that's great. And again, I sort of re-echo the fact that you guys are doing a phenomenal job for the state. You set a standard that other states look to in terms of how it is we're addressing orphan wells. Just none of this is super critical. It's just process improvement, right? And so, here we are dealing with this first case impression. And so, I think there's, always room for improvement, but you're killing it. So thank you very much. And yeah, send that around. That'd be great.
All right. Thank you.
Commissioner McGowan.
Thank you, Mr. Chair. Just one thing to add, and maybe you in your kind of laying out the kind of thought process, you covered this or meant to cover it. But I think the other piece that I would like the commission to consider is whether or not folks, so the per se process, and can we talk about whether or not you have to come in front of the commission, and then that triggers having a lawyer. And I think in this case, this entity had the resources to put all of this information together. And some people, if they are in a similar situation, might not have had these kinds of resources.
Yeah. Yeah, I think that's a good point and something that we can further deliberate on. So yeah, I mean, just for now, for anybody that's listening in, we've got 55 participants. If you think you've got a problem, bring it up to Scott Cuthbertson, and we'll attend. We will try to address it as best we can, and we'll continue to work on this process. So with that, I would look for a motion to adjourn.
We'll move.
Second.
Motion and a second to adjourn. All those in favor signify by saying aye.
Aye.
We are adjourned. See you next week, everybody.